Okay, good evening, class. Just want to make sure we're recording here. Looks like we are. And where we're going to start off tonight is in Chapter 5 in this segment. What we're going to be learning tonight is about contracts, elements of contracts, types of contracts. I'm going to look at a purchase and sale agreement, which is one of the most basic documents you're going to be looking at in your practice, in your everyday life. So in this segment, we'll be learning about contracts. And I'm going to jump ahead a little bit in Chapter 5. So those who have the book, it will be Chapter 5. And we're going to jump right over to general contract classifications. So in your book, on 5-2, they're going to be general contract classifications. And the first section is going to be talking about expressed or implied contracts. An express contract is a contract that is specific, and usually it's in writing. So usually the thoughts of the parties are condensed to a writing. Okay, so that's an express contract, as in comparison to an implied contract, which is an agreement between the parties, and it's determined by their actions. And in the book on 5-3, it'll give you an example of an automobile owner pulling into a gas station saying to the attendant, "Fill her up." That's an implied contract. They didn't sit down and write a formal contract about filling up the gas tank. So that's an implied contract. So express versus implied. Then the next classification that we're going to have is bilateral versus unilateral. The bilateral agreement is where one party agrees to do something and the other party, the second party, agrees to do something in return. So there's more or less a meeting of the minds, right? That's what they say in short, is a meeting of the minds. It's bilateral. As opposed to a unilateral contract where one party agrees to do something if the other party does something else. But the second party doesn't have to do that other event. And the example that they give you on 5-3 for a unilateral contract is posting a reward for an animal, a lost animal. And so the neighbors of the person who lost the animal aren't under any obligation to go out and find that animal. But if they do go out and find that dog and they bring it back to that owner, then the owner is responsible to pay that reward. And so it's a unilateral contract. The other parties aren't bound to do it, but if they do it, then the party that made the offer is bound. And then the next type of classification we have is executory and executed. And as I always say to my classes, don't confuse executed with signing a contract, and they will try to confuse you on the test. So executed in this instance is going to mean both parties have completed everything that is necessary in the contract, and the contract is final. So the parties have fully performed. As opposed to executory. And an executory contract is where the two parties have agreed to do certain things in the contract, but not all those obligations have been met. So in other words, not all of the actions have been conducted by the parties. And so therefore the contract itself is not completed. So those are the types of classifications. Now, what I usually say to my classes is, can we have an expressed, bilateral, executed contract? Well, yeah, we're going to be learning in a second that the purchase and sale agreement is expressed. It is a bilateral contract, right? It is reduced to writing, and there's a meeting of minds. And it can be executed or executory. So when the property is sold or purchased, the contract is completed, and so therefore it's executed. Up until that point where the sale happens, it's executory. So you can have an express bilateral, executed, or executory contract. And I usually say, well, can we have an expressed unilateral? No, usually the unilateral contracts are based upon action. But you could also make an argument here that a reward posted on a pole could be an expressed contract, but there really wasn't a meeting of the minds. So you really can't have that. So, but the point that I want to make here is that you can have classifications existing in one contract, different classifications existing in one contract. Okay, so on we move. to the elements of contract. Okay, and the basic elements of contract, to have a contract, in other words, how do you get a contract? Well, you have to have an offer and acceptance. There must be, again, the meeting of the minds. There must be an offeror, the person who puts forth the offer, right? Who tenders the offer, as we say, and the person who receives the offer is the EE word, as I say, the offeree. So there's an offeror and an offeree. Usually with every contract is going to, or actually not usually, always with every contract is going to be consideration. And that's something of value. Now, consideration is what we use to bind a contract. And so it doesn't necessarily have to be thousands and thousands of dollars. It could be $1. It could be a promise to do something. It's got to be something of value. It could be tangible, something in the form of a dollar or cash, right, as it says here in the outline. It's usually tangible, but it can be a promise to do something as well, too. Okay, so consideration, something of value has to be given at the time of signing the contract in order to bind it. It's got to be legal, right? So the contract must deal with something that's within the law. You can't have a contract to sell drugs. And once upon a time, it's used to say in Massachusetts, you can't have a contract to gamble. Now you can, okay? So, but it has to be legal. Both parties have to be competent, okay? And so you can't have somebody that is senile, as it says in the book, suffering from Alzheimer's. You can't have someone who is drinking or drunk. I actually had, as I tell my classes, I actually had somebody show up to a closing drunk. I had to send that person home because the idea is they could argue that they weren't competent at the time of signing their promissory note and their mortgage, and so they could say it was void, right? Also, in this category of competency, we talk about minors. And so with minors, it's kind of a funny topic because when the contract is formed, the contract is valid. So if you have an adult and a minor signing a contract, like for the sale of a car, it is valid when it's signed. However, the minor has the ability to void that contract. And so there's a question of competency when it comes to minors. And so for this particular segment, or part of the segment, when we're talking about competency, all parties have to be competent. And if the child is too small, then they're not going to be competent. They can't sign the contract. But when you have a teenager and they're signing for a car, we'll see a little bit later on in another segment what happens with that particular minor. The book also goes on to talk about power of attorney, so that if a person is not competent, such as a person suffering from senility or from Alzheimer's, that a power of attorney could be used in the place of that person's signature. So in other words, an agent can sign on behalf of that signature, for that individual. And then the last element of contract is consent. And so it's got to be the party's free act and deed, as we say. And sometimes we have notaries. Well, I'm a notary, and when I sit down and I have someone sign a deed, I'm going to say to them, are you signing of your own free act and deed? Because we want to make sure that there is no duress in the contract. It's got to be a free act, in other words. So those are the basic elements of contracts and how you make up a contract. Now, the book also goes into talk about how contracts are not enforceable or unenforceable contracts. And so in our outline here, we're going to see a couple of categories. Statute of limitations, okay? It's the legal limit to take action to enforce a contract. So if there's a breach of a contract down the line and it takes the party 7 years to bring that legal action against the party that breached, well, the party that breached can raise a defense. They can say there was no contract now because the statute of limitations has run its course. Massachusetts statute of limitations on contracts is generally 6 years. It can be extended depending on the type of contract that's there. But in general, our statute of limitations on contracts is 6 years. So what that means is a party that's suffering from another party not performing on a contract has a 6-year period in which to establish a legal action against the breaching party. If they don't establish the action in the 6-year period, then they are out in accordance with the statute of frauds. It's a defense. Another defense here is latches, okay? And what that basically means is similar to the statute of frauds, but the time limit is set by not by statute, but by a reasonable time as determined by the court. So when it comes to latches, a court might turn around and say, well, yeah, the action in our previous scenario, yeah, the action was brought in 7 years, but it would have taken a reasonable person 7 years to figure out that there was a breach of the contract. So therefore, we're going to allow that that action to go forward. They're going to, in essence, allow the action through latches. Okay, and then there's estoppel. Okay, and so what I usually say is a general thing is we say one party doesn't necessarily have clean hands, and so therefore there's an issue. So when it says under the estoppel provision here on an unenforceable contract, a previous action or statement can be used to hold a party accountable, even if it's later proved to be an error. That means that a party is prevented by their own past actions from claiming a right against another party. So if a party goes to raise an action against another party, and that party that's taking the legal action doesn't have clean hands, they did something wrong in the past, they may be stopped from enforcing that contract. So those are the general areas of unenforceable contract. They're basically defenses against contract. And then the book goes on 5-5 to talk about a termination of an offer. And so when you have an offer in place, one party is putting forth an offer, and what I usually say to my classes is there's an offeror, right? A person who usually that's the buyer in any given situation when you're talking about real estate. There's the offeree who's receiving the offer. That usually is the seller in this scenario. So now how does an offer die? Okay, a termination of an offer. Well, one way is by the death of the offeror. It's the person that's giving the offer, right? So an offer extended on Tuesday afternoon cannot be accepted on Wednesday morning if one of the offerors has died on Tuesday. Okay, so we get a death of one of the offerors before the offer is accepted. Then there's also a time limit on every offer that's submitted under real estate. Anyway, it specifically has in the form a provision that talks about a time frame in which the offer must be accepted. If that time frame, if I say to you, I'm going to give you this offer to buy your property for $500,000, you have until Tuesday to accept it, and then on Wednesday you come back and try to accept it, I may have already terminated the offer. Okay, so as it says here, it's recommended to make an offer good for a specified period of time. Okay, you can't have it accepted too late. Or let's see, number 3 is an offer is revoked prior to acceptance. So let's say on Monday I make an offer to buy a piece of property for $500,000, and I say you have till Wednesday to accept it, but then on Tuesday I revoke it. I pull it back and I say, you know what, I don't want to buy your property anymore. On Wednesday you can't come to me and say, I'll accept your offer. I've already revoked it prior to you accepting it. So that kills an offer. What else kills an offer? Well, doesn't necessarily kill an offer, but what happens is when an offer is accepted, the offer is terminated and we have a contract. Okay, a contract's formed under that in this scenario. And in Massachusetts, folks, a offer to purchase real estate once it's accepted by the seller is a binding contract on the parties. Okay. And number 5, a counteroffer. So let's say I make an offer to you. I want to buy your property for $500,000, and you say to me, "Well, Dave, that's a good offer, but I want to sell my property for $600,000. Give me $600,000, and I'll take it." Well, you just counteroffered me. You killed my offer. You laid your offer on top of it, and now you're the offeror, and I'm the offeree. You say to me, "Buy my property for $600,000." You become the offeror. I come back and I say, "Well, $600,000 is too much for me, my friend, but I'll give you $550,000." Now I just killed your offer. I became the offeror, and I offered to buy your property for $550,000. You're now the offeree. So in this scenario, our roles change back and forth as we bargain, as we negotiate. And so that's a counteroffer situation. And each time there's a counteroffer tendered by one party or given by one party, the prior offer is killed. So that's the way an offer can be killed as well. Now, as I mentioned before when we talked about valid, void, and voidable contracts, As it says, it's just the outline here, but in the book it's going to say to you, a valid contract is one is binding force on the parties, as in the majority of contracts. K means contract on my outline. Where the legal qualifications have been met, right? All of our components of contract are there. A void contract is one where there's no binding force that it ever exists, right? Because maybe it's illegal. It's an illegal partnership, okay? It's void. And then a voidable contract is a contract that exists, but one party may make the contract void. And as I mentioned here, a contract, a K, between an adult and a minor, as I mentioned to you before, a minor buying an automobile, right? That's why you have these dealerships looking to get co-signers with the minors, because they want an adult tied to that contract as well. The reason is the minor by themselves can void the contract. They can sign, get the car, and it'll be a valid contract, but then the minor can turn around and just say, I don't want it anymore, and void the contract on the dealership. So therefore, the dealership wants to get an adult, a person of age of majority, over 18 in Massachusetts, to sign off on the contract, to bind it, and it will not be voidable. Okay, so now we move along, and a purchase and sale agreement is where we're going to finalize this segment of our contract speech, or my contract speech. Purchase and sale agreement, and for this, there's going to be some basic components that we need inside the purchase and sale agreement to make it valid. And I will pull up an actual purchase and sale agreement here under the Greater Boston Real Estate Board. This is what your purchase and sale agreement is going to look like. There are basically two types of forms in Massachusetts that realtors will use. This is one of them. And there is another form for standard form purchase and sale agreement. So what is inside a purchase and sale agreement? Well, in your book, it's going to be on 5-6. It's going to talk about what the purchase and sale agreement is. And basically, this is a contract between the buyer and the seller. There's no other parties involved in this contract. Although the realtors are listed in this contract, they are not parties to this contract. The contract is between the buyer and the seller for the sale or the purchase of a piece of real estate. And in Massachusetts, the book will mention, you'll see a few times, this whole idea of the statute of frauds. Well, it is a law in Massachusetts that any contract for the sale of real estate must be in writing. So the statute of frauds dictates any contract for the sale of real estate must be in writing. So here you are. Contract, which is a Greater Boston Real Estate Board purchase and sale agreement. And so the first section we're going to see here is the seller and the buyer. They must be named. The parties must be identified. The date of the contract is going to be above here. Down below, we're going to actually describe the real estate. So we need identification of the parties. We need a description of the land being sold, as it says in the book here. Well, here it is, folks. And typically we use the address, but we also say, also known as, so it'll be number 13 Happy Street in Boston, Massachusetts. So the address will be here. And then it will say, as further described, and the deed dated, whatever the date is, December 15th, 1987, and further recorded in book 1000, page 200. Okay, it'll describe the real estate, and it will give both the address and the way we can identify the property at the Registry of Deeds, which we'll talk about in another segment. And so that's in there. Price or consideration is the next component you're going to see in the book, and it's right here on provision 6 in this form. And you're going to see that is the consideration that is binding. You're going to see the offer section here, right? So here's your deposit. That comes from the offer, okay? And so there'll be a deposit that will be made as consideration to bind the contract. It'll be specified here. You'll get a little bit of a breakdown of the sale price. Those numbers are carried forth from the offer form, and this is going to be your consideration. Normally, your deposits in a real estate deal are going to be 5% or less of the purchase price. Okay, 5% or less is usually your deposit in a residential deal. Okay, and then the deposit, as the book talks about, is actually held by an escrow agent. Now, an escrow agent is the party that is responsible for the deposit money. The money is not given to the seller directly. It's either given to the listing agent, which is the seller's broker, or the seller's attorney. The seller's party holds the deposit. It's not the seller, but the seller, one of the seller's agents, will hold a deposit and normally act as what we say the escrow agent. And so that particular person has a high fiduciary responsibility, a high responsibility to manage those funds and put them in a separate escrow account that cannot be commingled with that agent's business account. So if I'm the seller's attorney and I take the deposit from the buyer, I put it into my client funds account, I cannot commingle that deposit with my operating account to run my business. It has to stay separate. And I have a responsibility as the escrow agent at that point to account for the funds at the time of closing. I have to make sure that those funds are available and they're accounted for at closing. So that's what happens with the deposit. It's not given to the seller. And then we need a date where the performance must take place. That is in provision 8, folks, over here. Time of performance, right here, okay? And so it's going to be such deed is to be delivered at whatever time in the day, right, on whatever date it is, at the registry of deeds or unless otherwise agreed in writing by the parties. Usually it's at the office of the buyer's attorney or the closing attorney is where the closing does occur. And so that closing date is essential because it's going to say when the whole transaction is supposed to happen. In our contracts, there's a term called time is of the essence. Not a term, but a saying. Time is of the essence. And so it must be performed on time. That's the time, that's the section where we're going to talk about when this is supposed to happen. And then the signatures of the parties have to be included on this contract in order to make it valid, and that's at the bottom. The parties will be signing here. Okay? So that's the basics of a purchase and sale agreement, and this is actually what a purchase and sale agreement looks like in Massachusetts. Like I say, there is another form, the Mass Association of Realtors form, but it's pretty similar. There is some extra language in there, but for the most part, your components are the same. The elements of your contract have to be the same for them to be valid. So that is my segment on contracts, and I encourage you to, as always, read the book and do the assignment as stated. And of course, we will be chatting along the way. I'll make sure that I do touch base with each of you to make sure you understand the concepts that are being conveyed here. Alrighty, so I thank you for your time, and I look forward to seeing you in the next segment. I have to stop recording here. Good night.